hopefully that the new dealers in Chapter 10, they diagnosed the problem correctly, they just didn't come up with the right solution. I try to sort of outline what a better solution would look like in a new form of Chapter 10, but again, this would apply to the very biggest companies. So that in short is basically the proposal, and if we have, I don't know if we're going to do questions all at the end of all three presentations, or if anyone wants to jump in now, we'll be happy to take it as well. But you can cogitate on it a bit during the other two presentations maybe and come back to me at the end.
Going once, going twice. All right. So, hello everybody, I'm Doug Cortez, and I'm currently working on a journal article that's proposing to bring back subchapter 5 debt limit to 7.5 million. And to be honest with you, I'm compiling. I'm in the process now of compiling data because, to be honest with you, I mean, that's just a number you pluck out of the air, right? What's 7.5 million? Is it really based upon this number, 7.5 million or 10 million or 20 million? It's more along the lines of like how complex is the case, because you can have a relatively simple $100 million case, right? You have one big secured lender, maybe a few relatively minor, small, unsecured lenders, and it's just not that complicated. So why not go ahead and use the process of a simpler one? But my thought, my argument right now is to at least come back and bring it back to $7.5 million, because it's just judicial economy, all of efficiency, and all of those things. So let me switch over. He covered some things that I had here, talking about history of chapter 10 and chapter X and XI and all that. So and I because of the job that I have now with the university, I run basically an entrepreneurship clinic, a transaction clinic, and as well as nonprofit stuff. So, and I get most of my clients from the Small Business Administration. So I've developed a really good relationship with them, and just talking to them about businesses and things. So kind of the middle and small businesses of America are these incubators that really, it really is a lifeblood of the economy, of what's going on, especially, in smaller towns and things like that all across America. And I think that, the CARES Act, when they put the limit, when they bumped it up to $7.5 million, I think it was something of an unintentional kind of test tube, right? And all of a sudden everybody found out, it's like, wait a minute, these are great. There are some things, of course, that people object to, there's no creditor committee. And not only that, but as an unsecured creditors committee, as an unsecured creditor, if I want to do anything, I'm going to have to pay for it. I can't just get this committee that, the debtor has to pay for and things like that. But what it's demonstrated is, one, the confirmation rate is double that of what they were. If you compare, compare apples to apples and oranges to oranges. They get confirmation about 4 months faster. Confirmation rates are really high. It's let me see, it's about 6 to 7 months versus 10 to 11 months outside of subchapter 5. And I think some of those objections along the lines, again, talking about the creditors, what happens is, because of the efficiency, there actually is a higher level of return to unsecured creditors. And because of the low cost and the rapidity, how rapidly, the case progresses. Let's see, dismissal rate also it's about 30% relative to regular Chapter 11 cases, which are somewhere around 50 and a little bit above 50%. So the success rate, all of these things, and again, like I said, I'm in the process of starting now to do really the challenging part is find this data and prove it one way or the other. And I'm open-minded. Maybe what the data shows ultimately is like, this is not a great idea, but I highly doubt it. And it captures, instead of just being like these super, super small businesses, I mean, really, it's like, $3 to $4 million is not, right now in the economy in America, I mean, unless you're really, really in a small town, then, $3 or $4 million it's not much, I mean, for a business to be operating under, right? Another objection, that people have, but again, I think that is the exclusivity in following the plan and stuff. But ultimately, there's our requirement that it has to be fair and equitable, right? So the court and the trustee can take these, you can come in, again, unfortunately, you're gonna have to pay a lawyer, but, you can come in and you can argue about whether or not it's fair and equitable. So it's not like they're without any kind of remedy or anything along those lines. So really that's really the bulk of my argument that I have at this point. And again, I'm open to, and you're welcome to contact me if you have some other thoughts on it. And again, if you have any questions, you can ask questions now, or you can think about them for a little while and let Martin kind of do his spiel. Thank you.
Okay, thanks for having me. So Buzz Rochelle asked me to speak about, or think about and speak about what I would do if I were overhauling the bankruptcy code and what lessons I've learned that might inform that process. So I'm going to try to quickly cover both. The next bankruptcy code overhaul, in my view, should start with some thinking about the contents of the bankruptcy power. There are two specific reasons why the bankruptcy power remains and will probably always remain very mysterious. Largely because Article 3 of the Constitution bars advisory opinions. No reported opinion definitively specifies what can and cannot be done under the bankruptcy power. The Supreme Court wrote, the subject of bankruptcies is incapable of final definition. The concept changes. It has been recognized that it is not limited to the connotation of the phrase in England or the States at the time of the formulation of the Constitution. So that's one source of the mystery. Another source of the mystery, which few people have recognized or written about, is that it's permissible, according to the Supreme Court, for a statute to violate other provisions of the Constitution if the statute is enacted in furtherance of a provision of the Constitution or something that is necessary or incidental to carrying it out. There are several decisions I cite in the few pages of my materials that give the Supreme Court's ruling that is possible. And the example I would give you is how the Bankruptcy Code, as a matter of everyday occurrence, violates the Fifth Amendment. When you take back from a creditor money that was validly paid to the creditor to satisfy a valid state law debt, you are taking that creditor's money. When you take someone's house, you have to pay for it under the Fifth Amendment. Why don't you have to pay if Congress is enacting a preference law for the benefit of equality of distribution for all creditors? Why shouldn't you have to pay for that? Well, if you do have to pay for that, you'd eliminate the purpose of having preferences in the beginning. That's just one example. The Bankruptcy Code eliminates the value of valid state law liens. If you have an unperfected lien, perfectly valid under state law, the trustee's hypothetical lien status eliminates that value like that. You don't get compensated for it. So my point is that even while there are Supreme Court decisions going back to the Radford decision that struck down the first version of the Fraser-Linkey Act, even though there are those decisions that say the Fifth Amendment applies in bankruptcy, it doesn't always apply. And that's just an example of the ability of Congress to violate one constitutional provision if it's carrying out another. So anyway, those two items, in my view, create this constant mystery about what the bankruptcy power can do. Now, we do know there are some limits on what it cannot do. The Supreme Court has written that Congress may only prescribe regulations concerning discharging bankruptcy that are not so grossly unreasonable as to be incompatible with fundamental law. So, what's fundamental law? One of the things that the Supreme Court has approved time and again as being fundamental law is the right to sue. Why? Because there's no liberty right and there's no property right that any of us have that have any meaning if you can't vindicate it by suing. So, what is that relevant to? In my research, it was very relevant to whether coerced releases in Purdue Pharma could be within the bankruptcy power. Because by definition, or the way they set it up in Purdue Pharma, you never got to sue. You never got to sue the Sackler family to see what your claim was. And you never got to determine exactly how much value you were going to get if that original plan had been confirmed. As I mentioned earlier, if your house is condemned, you get a hearing on the value of the house, and you get its value. If a claim against a non-debtor third party is taken away from you, you're not given a trial as to what that claim was and how much it's worth, and you don't have any assurance you're going to get its value. So in my view, although the Supreme Court settled the issue by saying, well, Congress hasn't authorized coerced releases in the first place, I think if they said it had, they would have had to get to whether that's included in the bankruptcy power, and because it violates the right to sue, it would have concluded that it's illegal under the bankruptcy power, or unconstitutional. Now, how can we use the bankruptcy power, the expansive part of it, to solve more problems? I think one area it could clearly be used is to be made applicable to mass tort situations. The estimation power in bankruptcy is truly magical. It cuts off 5 and 10 years out of litigation, and it saves tens and hundreds of millions of dollars of litigation costs. In the Enron case, as I told the judge at that time, Judge Gonzalez, I could have supported my children and grandchildren by litigating all of the fraud claims in the Enron case. And my firm could have done the same for all of its partners. But instead, we came in with an estimation motion that said, hey, you get 15 pages apiece, you get 15 minutes of argument apiece, and anything more the judge wants to give you, and the judge will decide. And creditors were calling me left and right, saying, Marty, you're going to look like a jerk, like an idiot, but if you settle my case, I won't raise this objection. And I deferred. I said, no, let's roll the dice and take our chances. The judge granted our estimation motion, and guess how many times he had to rule on these estimation disputes? 0, because everyone settled once we had that order. Now, they're not all that successful necessarily, but they do save decades of litigation and hundreds of billions of dollars of cost. A corollary to what I just said is I would, as much as I have enormous respect for Circuit Judge Ambrose in the Third Circuit, I respectfully disagree with his decision in LTO management for a very simple reason. At its core, what was at issue in that case is, do you give the victims the choice? Take the dollars identified for you in the medical matrix, or hold out for a jury trial under 28 U.S.C. 1411. What victim would not want to have that choice? It's incredible to me. Now, why were people objecting? Well, there were arguments made that the attorneys were really objecting because they would have gotten a higher percentage fee outside of bankruptcy than in. Who knows whether that's right? But the concept of depriving thousands of victims of the right to choose between a medical matrix amount for cash and holding out for a jury trial, to me, is criminal. It should never have been done. And the fact is, in '78, Congress eliminated the insolvency requirement, did not put a good faith filing requirement into Chapter 11, and the court shouldn't do what exactly Congress did not do. Now, in Judge Ambrose's favor, I know a lot of circuit courts vaguely at least support what he was doing, but bottom line, I don't think it's good for the profession. Now, what should we learn from history? The biggest thing I learned from the history of the Bankruptcy Reform Act is there's no debtor's lobby. When the Reform Act was enacted, it was the best bankruptcy professors in the nation, the best practitioners in the nation, the best judges, and they put together a balanced statute for debtors and creditors. That's when you enact the code. Every amendment after that is pro-creditor. Why? Because there's no such thing as a debtor's lobby. So we have lobbies of all types, for landlords, for secured claim holders, bondholders, fishermen, warehouse creditors, aircraft creditors, sea vessel lenders, but there's no lobby for debtors, and that explains most of the amendments we've had. And we had an exclusivity amendment. A lot of soapbox hoopla about bankruptcy is to get creditors paid, not to make the professionals rich. Yeah, all true. But what has the 18-month limitation really done? It's given rise to what I call the undervaluation scam. You don't have enough time to fix the business, have better results, so you value it based on old numbers, which means the most senior or secured creditors get disproportionately high portions of the value, and everyone else loses. Now, you did pay the professionals less, I'll grant you that, but you totally distorted the allocation of the value of the reorganized debtor, which goes on through today. What reason would there be to pay landlords more than the fair rental value of their property during the Chapter 11 case? There's no reason. The abuse under the old law was there was no time limit to pay the rent, not that the rent was too low. We need to go back to the fair rental value. In individual bankruptcies, means testing came in because the banks thought they'd make billions on their credit cards if they could limit Chapter 7 liquidation through the means test. I think it's been proven since that it really hasn't made the banks the money they thought they would make. But this needs to be eliminated from the code if we're serious about a fresh start. And the single asset real estate provisions. Why make it impossible to reorganize what has traditionally been the way entrepreneurial Americans with little money try to get into business and make money? These are just some examples. Since I think we have time left, I'm going to address a few remarks to Professor Rubin. First, I am definitely, immediately after this, buying his book on Amazon. I'm pre-ordering it. But I'm pre-ordering it with the understanding in my own mind that I will respectfully disagree with a mandatory Chapter 10 trustee. Why? First, I think we learned the lesson under the Act of 1898, that causes large companies not to file until it's too late to save themselves. Second, I think the concept of a mandatory trustee would not be popular debtors or creditors. Creditors don't want an unknown trustee who's going to hold up their confirmation of a pre-packed or pre-arranged plan. They will only want a mandatory trustee if they get to pick it. Well, today in the code, creditors can pick it. There's a provision there, believe it or not, almost never used, except I think by me, that creditors can elect a trustee. But I'll tell you the lesson I learned there. Just try it if you want to make the U.S. trustee your arch enemy for the rest of your life. They do not want to lose that power of appointment. And boy, when I tried it in a case in Maryland with the half-family real estate empire, the trustee was at my throat. But we made a good deal and everyone was happy at the end of the day. And little did I know that that trustee, who I inflamed, was Cliff White, who became head of the program for the next 10, 15 years. But it was still an eye-opening experience. So, and what is this trustee going to do for us? I am sympathetic to the notion that there are a lot of pre-packs that are pre-arranged cases where stuff is designed to sort of avoid judicial review, to slip payment of pre-petition debt and other things, to cover up the control person's agenda perhaps, to create claims that unsecured claims that won't be paid and do it over and over again. There are a lot of potential evils that perhaps a trustee would avoid. But those evils can be avoided under the code today, as long as someone, whether it's the committee or a victim or someone, brings it to the court's attention, and the court can do with it what it believes appropriate under the circumstances. I like the flexibility. And I'll have to let Professor Lubin respond. Mandatory takes away the flexibility, and you really have to give bankruptcy judges credit for being able to assess the facts on the ground to see if it makes sense. I'll shut up there so that people can respond and ask questions.
So let me just, I'll briefly respond and then we can have a broader discussion. I mean, I think on the issue of they'll file too late if there's a mandatory trustee, I think they already filed too late today, right? All these LMEs that we heard about this morning, right? I mean, it's all about basically avoiding the inevitable in a lot of times, and sometimes playing out the sponsor's role for a little bit longer to get one more dividend or one more fee or something like that until finally that cash flow has to end. So in other words, I'm not sure that we don't already file too late, so I'm not terribly worried about that issue. The nobody will want issue is also one that, like I said, kind of existed previously under old Chapter 10, and this is why cases like W.T. Grant ended up in Chapter XI 11, where it should never have been, right? I mean, this was a ridiculous case to be in what Chapter XI was essentially a composition provision. It was the extension of old Section 12 from the prior 1898 Act. It only applied to unsecured creditors. It was never designed to deal with a publicly traded company. And there was W.T. Grant with $1 billion of debt and something like 30,000 public shareholders and filing under it. It was ridiculous that it was ever there. So that was a problem, and I think we need to anticipate that, right, and provide other avenues. I suggest, I didn't get to talk about it in the paper, but the U.S. might benefit from something that looks a little bit like a scheme of arrangement if we had guardrails on there to keep the sort of smaller unsecured creditors out of that process. Then we need to incentivize the institutional players to use that tool if they want to avoid Chapter 10. And, again, if you provide a viable option to Chapter 10, I think that the overall scheme, the overall process could work. So I think those are all things. I think at heart, what I view current Chapter 11 as sort of a product of this time. Namely, there was a huge deregulatory movement going on in the late 70s and early 80s. I think Chapter 11 reflects that time period, but I also think maybe now we've gone a little bit too far the other direction. We need to think about it again.
Well, I kind of have a question with respect to So, I mean, so the Fifth Amendment and the taking clause, that's the government doing the taking, as opposed to a formal way that the government has set up for people to go through bankruptcy. I mean, there's gonna be winners and losers, one way or the other, but it's not the government taking, so therefore you need to get compensated, like under which is how I read the Fifth Amendment.
The Supreme Court, though, has explained that while it's not the government itself taking something for the public good, it's the government enacting a statute that takes a creditor's collateral, for instance, or takes something else for a public purpose. And they consistently apply the Fifth Amendment to that, except in the cases of preferences and hypothetical liens and the like. And I mean, it's actually the First Circuit recently rendered a decision against me, where they sort of did what you did. They defined the taking as not a taking. Okay, so the Fifth Amendment didn't apply. They did that. I raised the preference argument to them, and they said, "Well, not a taking." Well, how is it not a taking? You're just saying it's not a taking, so the Fifth Amendment won't apply. You're really saying the Fifth Amendment won't apply. But anyway, they do interpret the bankruptcy law as an act by the government for the public good, and because it results in various takings, Fifth Amendment applies.
But then ultimately, I mean, what are you gonna do? I mean, it's something of a zero-sum game, right? Where it's like, here's a pie, however you want to define it and all these things. There's just not enough to fully compensate everyone. So somebody's gonna lose something. And so you say, all right, here's a way that we can do it that's fair and equitable as much as we can, and this is how we do it. But I mean, I think there's good and strong arguments both ways, and I'm definitely, we're not gonna settle right here, right now, but go ahead.
It's dividing the pot is not the taking. Taking money out of the creditor's hands or making its lien worthless, that's a real taking. Just ask the creditor. They don't have as much at the end as they had at the beginning. So they lost. But I think in terms of reforming the bankruptcy law, we really ought to use the lessons we've learned. I mean, I don't think people use the estimation power in bankruptcy nearly enough. I mean, it saves so much time and so much money, and creditors are really so happy with it when they see it work. In the bankruptcy of Dewey and LaBeouf, which I unfortunately had to plan because I was there briefly before I went to Proskauer from Wabagatchel. We basically had tons of claims. Every large firm bankruptcy had lasted at least 10 years because of all the litigation. We used estimation, it was over in less than a year. It's really a magical power, and what I'm trying to urge is that we ought to use our imaginations and practicality to see how we can use some of these magical powers to solve more problems. Because they do solve problems pretty well.
There is, I was going to say, just sort of tag on to that though, there is at least one Supreme Court decision that says the Congress can't do under the bankruptcy clause what it couldn't do under the Commerce Clause. So you always have to sort of think about that limitation as well.
Is this on?
It is.
One thing that we've been hearing, and this is not a new thing. My dad wrote an article in Kansas Law Review in 1962 about how do you encourage people to file sooner rather than later. And certainly that's, when you bring a carcass rather than a fatted calf to the party, things turn out differently. But what I'm wondering about is are there ways that bankruptcy, which today seems to me very much like a stockyard / packing plant, rather than a hospital, are there ways under the current code, or might there be ways proposable and able to put into effect that could be something other than you show up to us, we're going to sell your kidneys to somebody? How can we make this a place to regenerate, a system to regenerate and rebuild rather than simply destroy?
Well, for my position, one, again, like 40% of the economy is small businesses, and my suggestion about subchapter 5. So, but the larger question, gentlemen.
I mean, I think one issue that we would have to think about, this is sort of tying my two panels together, is whether there needs to be a more robust duty on boards to consider these issues earlier. Now, whether that's a creature of federal or state law, it probably has to be federal law, but I think since it would be pre-bankruptcy, it'd have to be a statute, which then gets us into the issue of can we get Congress to actually do anything like that? But that would be if there was more of an incentive for boards to focus on these issues earlier, I think it would be beneficial, for sure.
I certainly agree that the problem should be solved not by the government, but at the board level, by the company. And in fact, one of the first pieces of advice I give any board of directors is you have an obligation to dispassionately look at every plausible solution to your distress, whatever that is, and then figure out of the plausible solutions which is the best, which is often the least worst. And that actually gives rise to the application of prospect theory to the work we all do. Prospect theory was developed by a fellow named Daniel Kahneman, and it measures human beings' benefit and detriment, or preference and hatred of different financial results. And the bottom line to prospect theory is we're all great at determining the best outcome if it's positive. If you have an array of outcomes that are all somewhat distasteful, people's decision-making process freezes. That explains how Eastman Kodak, after being head of the industry, basically liquidated, lost 60,000 jobs, billions of money, all that stuff. That's how Lehman never planned for Chapter 11, because rather than choose the least worst, they did nothing, which is equivalent to praying for a miracle. So the bottom line, Buzz, I think the solution to your issue goes more to the boardroom than to Congress. We have two questions, I think.
To what extent, general question for the panel, to what extent do you feel that the rise in bankruptcy alternatives are filling this need, or acting, at least right now, the interim as a stopgap for bankruptcy reform? Like, so for example, right, the issue that you hear about Chapter 11 not working and leading to a delay is it's too expensive. Well, now I think a lot of states, right, have promulgated model receivership statutes that resemble the code in many, many ways without crossing the line into preemption issues. So I think, you know, what's your thoughts on that?
Well, I do think there's actually a risk with many of those statutes have gotten so elaborate that there is a risk of preemption. I mean, there's obviously one sort of oddball Ninth Circuit case that preempts part of California's assignment for the benefit of creditors provision. I mean, that one is weird, but there is also a lot of older case law back before Congress got into enacting regular bankruptcy laws about what the states can and cannot do, and I'm not sure the states have always paid attention to that older case law.
I think we're about out of time, but I don't know if you can real quickly
Yeah, I'll be quick. There's about 15 questions I have, but I'll just ask one. What can I do?
Me too.
When the code was first enacted in '78, there was this assumption that what we were doing was saving jobs. We were reorganizing companies. Over the decades, what we've seen, I think, is that that's not really the case, especially with larger companies. That actually what happens is they get chopped up and sold off in bits and pieces, and jobs may or may not survive. I think Sub 5 is different, but my question is, do you think that we need to revisit that assumption about what the bankruptcy code should be doing?
No, I take issue with the premise, respectfully, Judge.
No, it's all right.
And the reason is this.
All due respect means you probably don't respect me.
You know better. No, my Enron case forever will be known as a fraud case and a liquidation. I am extremely proud of that case because while we did sell all the businesses, we sold them as going concerns, including the trading operation, and we saved the job and ultimately paid most of the creditors. So the reason I take issue is I'm not sure that it is resulting in a loss of jobs. I think it's maximizing at least the retention of the jobs that can be retained. Now, if you have the first question you ask a company when it comes to you is, do you have a viable core business? If you don't, you should be liquidated. If you do, we'll save it, and the jobs will be saved with it. That's my view.
Wrap us up.
Yeah, thank you very much.
All right, finally, folks, it's the session we've all been waiting for. Today, it is Hail to the Chiefs. Our moderator for this session is my good friend Deborah Williamson of Dykema. And with Chief Judge Jernigan graciously pulling double duty today, we have our first Chief Judge, Craig Gargata of the Western District of Texas. Appointed to the bench in 2007, Judge Gargata became Chief Judge in 2021. He is the former law clerk for the Honorable Ronnie B. King, as well as having served as a former Assistant U.S. Attorney for 17 years. A member of the National Conference of Bankruptcy Judges, the Federal Bar Association, the Texas Aggie Bar Association, and a founding member of the Larry E. Kelly Bankruptcy and Court. Judge Gargata also provides instruction at St. Mary's School of Law. He serves as an editor for the American Bankruptcy Law Journal and holds both an undergraduate degree and his MBA from Texas A&M, in addition to his JD from St. Mary's. A round of applause for Judge Gargata. With them is the Honorable Brenda T. Rhodes, who is currently serving her second term as Chief Judge of the Eastern District of Texas, where she has presided over 100,000 cases during her judicial tenure. Having immigrated from Seoul, Korea as a young child, Judge Rhodes formerly practiced at Aiken Gum, Weil, Gotshal, and Baker Botts. She is also very active in supporting the current and next generations of lawyers, having served as an officer for NAPABA, chair for the Asian Pacific Interest Section of the State Bar of council member for the Council on Legal Education Opportunity in association with the ABA Fund for Justice, and she is a member of the John C. Ford Inn of Court and a fellow of the Texas Bar Foundation. Please join me in welcoming her. And batting cleanup is Judge Eduardo Rodriguez, Chief Judge for the Southern District of Texas, a certified mediator and board certified in consumer bankruptcy law. Judge Rodriguez was appointed in 2015. He is a frequent author and presenter on legal education. He is a former chair for the State Bar of Texas Bankruptcy Law Section and is among the most decorated public service attorneys across the nation. To wit, he is the recipient of the Robert B. Wilson Distinguished Service Award, a past member of the State Bar of Texas's Legal Services to the Poor in Civil Matters Committee, and he coordinates the State Bar's bankruptcy pro bono programs, for which he has been recognized for outstanding service and is one of only a very exclusive group of attorneys to be awarded for his distinguished pro bono service from Legal Services Corp and the Texas Access to Justice Foundation. He also was named 2015 Pro Bono Champion by the Texas Bar Journal and is the recipient of the 2018 Judge Merrill Hartman Pro Bono Award for his commitment to providing legal services access to the disadvantaged.
And thank you, each of you. I've had more fun preparing for this program than I deserve. Putting things in context real quickly. Our chief judges volunteer for this job as chief. They get no extra compensation, they get no reduced caseload, and they do this job, they do the job for all of us, and we'll hear more about that job, with, on top of everything else they do as a sitting bankruptcy judge here in Texas. And they are integral to, I think, the reputation Texas bankruptcy courts and Texas bankruptcy cases and practitioners have because of the commitment that we have from our chiefs. And I'm going to ask each one of you to kind of describe, how would you describe the role of chief? Judge Jernigan?
Well, I often say that you can analogize it to the situation of a corporation where you have a board of directors, that would be the judges, but your clerk is like the CEO of the organization, your bankruptcy clerk, and I guess the chief judge would be the chairman of the board. It really, I think, is a fair analogy because the clerk's personnel, the clerk of court, they handle day-to-day operations of the business of the bankruptcy court. And if you have a great clerk, hopefully being chief is not a regular daily big chunk of your day. Every once in a while with the clerk, and he or she seeks your input, but again, CEO is really the clerk of court, not the chief judge. The chief judge is kind of like the chairman of a board of directors. That's what I think. I don't know if my colleagues agree.
Yeah, I'd have to agree. Although I would say our clerk's office is probably more, or the clerk of court is more like a COO. They're in charge of the operations side of the clerk's office, right? And the business side. And we do have authority, but I think by statute, the chief judge has the responsibility for a lot of the executive level decisions, if you will. They're the executive of the court unit itself. And so, but we do, I think our fiduciary duties are pretty much exactly like a board of director in the sense that we're not doing the day-to-day operations, but we do have an obligation to oversee and make sure that statutory and other judicial policy obligations are being met. And the amount of work we do kind of varies on what's going on. Usually at budgetary time, we have a little bit more meetings, a little bit more issues. Depending on the number of colleagues you have more meetings on that side. Mine is easy because I just pick up the phone and call Judge Thursday and say, hey, you got 5 minutes? I need to talk to you about X. And so we're able to do it a little bit easier. I think when you're trying to coordinate the schedule of 6 judges or more, or any number of judges, it's always sort of difficult to do. So for us, it's simpler.
Well, and Judge Rodriguez, to that point, the balancing the workload, we've talked about that being a duty and an obligation, right?
Right, so I just, before I comment, I do want to make one observation. I've been standing in the back there off and on, starting at noon for a specific purpose. I wanted to observe and take a mental note of who left and didn't return, and those of you that remained. So I'll remember who those are when they computer for me. So to that point, to me, it was a little bit different because, our jobs at its core is about resolving cases, amongst a whole bunch of other stuff, but resolving cases. But when you get appointed chief, the order gets entered by the chief district judge. And in my particular experience, you wake up the next morning as chief judge, it really doesn't hit you until you walk in your chambers and all your nameplates are changed in the entire district, chief judge. And then it hits you. You realize, okay, it's different. It's not only about resolving cases, it's more now of guiding the court. And in my particular experience, that really became pretty apparent about 10 months into my tenure as being chief, as everybody knows what happened. And so it became more of a guiding of the court for me, access to the courts, workload distribution. We down to 4 judges out of 5. We're authorized 6 judgeships, which I've never filled the 6th spot. So we were down to 4 judges. We each had about 3,000 cases on our docket at the time. And so now we had an additional 3,000 we had to figure out what to do with and how we were going to redistribute those. And so it's a balancing act, dealing with caseloads, temperaments. We have a very good congenial court, but everybody has their opinions and the balance. And of course, our main concern is serving the public and serving the bar, because we did not want any interruption in business of the court, and that's a constant concern for all of us. And so it's a delicate balancing act of, you're sitting on the bench and you're hearing cases and you're worried about all these other administrative matters that may come before you, and you're getting emails while you're on the bench in the middle of trial, you can't do anything about it. And you have to ignore it because you have to focus on the matter before you. And it's distracting, but sometimes that's just the way it goes, and that's just an additional burden that's like when you become chief.
Judge Garada, anything to add to descriptions?
I agree with everything my colleagues have said. I'll pick up with the last point that Judge Rodriguez made, which is, I can't tell you how many times, I'm in the middle of an argument or taking evidence, and I'll get an email from my clerk of court, I really need to talk to you. Or he'll walk into the courtroom and say, Chief, I really need to talk to you. So there are aspects of the job that do require your immediate attention. Usually it relates to security and things like that. I kind of view my role, and I learned this from Judge King, who was a superb chief judge for many years, my obligation to my colleagues to make sure that they get everything that they need to do their job and to build consensus when we have to make a decision about court operations. I kind of view that's my job, is to make sure my colleagues have the tools and resources necessary so that they can do their jobs. I'm very blessed that I have 4 great colleagues. We get along really well, and all the decisions we arrive at, someone has to be the decision maker, but I think I could say with honesty that by and large everything we do is by consensus. So I agree with everything else that's been said, and I'll just add a little bit of another side to it.
And I forgot to mention, we hope to have some time for questions at the end, which depends on how we're going. But let's talk about it. Judge Rodriguez, you said, you kind of wake up and all of a sudden you're chief. What training did you receive to become chief of the district?
Well, in all fairness, I mean, when you get appointed to become a federal judge, as everybody knows, there's a baby judges training school that everybody's aware of. And it was kind of like that for chief judges. You're alerted 6 months prior to you becoming chief that there is a training session for all future chief judges and current chief judges throughout the country in Washington at the administrative office. And so I attended that meeting. I'm sure as all of us did. And it's just a huge nationwide meeting of all chief judges and future chief judges. But it's very general training about security. You have the marshal service, you have probation, you have sort of district and bankruptcy, and they go over all these different general topics that raise your awareness as chief that could come before you. But there's no real, book on here's how you act as chief judge, because it's just so different from court to court as to what you're going to do or what could even pop up on your radar daily. So it's impossible to really cover all those topics. Really, the training was more of, here we are, we're here to help you, we're here to assist you if you need anything. These are all the folks you can reach out to. These are the resources that are available should something arise. And I thought, well, okay, what could come up? Why would I need any of this? I know all of this already. I know the rules. I know my judges. And so it's just going to be judges meetings and dealing with rules and dealing with, the bar and the plans and forms and, just mundane stuff like that. But lo and behold, it was great that I had at least a resource I could turn to for whatever.
So, Judge Roach, you serve on the Committee for Executive Education. What is the role of that committee, and how does it impact the training for chief judges?
I'm fairly new to the committee, so let me start with that. But we're responsible for making sure what Judge Rodriguez experienced doesn't happen, I think. I hope. Or how to improve what we have, right? So I'm not on the committee that normally does the education for new judges. This is the executive education. So the executive education committee, it's a subset of the FJC, is about educating the clerks of court as well as the chief judges, the district court and the bankruptcy courts. So when you're a new chief judge, if we know about it ahead of time enough, you get invited to the next session, and that might be before you become chief judge. Sometimes it's after you become chief judge, but it's sort of supposed to coincide with that. So we do a chief judge's education session that usually lasts almost a week in Washington. You attend that with your clerk of court, and it literally is like drinking from the fire hose, because it's different from all the legal stuff we normally do on how to run your courtroom, how to handle legal matters, keeping up with rules and those kinds of things. This is about the business part of the courts that we really rarely have much to do with: budget, personnel, and security, space, all of those kinds of things that we don't deal with normally day in and day out as a sitting judge. So all of a sudden you get involved in all of these areas, and there's a lot of rules and regulations. And there's actually, there's this whole book that is so big that it's only online, because we can't have physical copies of it because it's so large and it's constantly changing. And so, and I'm talking about the judicial policies, right? So, but there's actually a chief judge's manual that's also electronic, but it's constantly changing and being updated. So we need to do a better job of that. But, so there's that education session, but you literally have people from the AO's office coming in and out of these meetings, saying, I'm the head of this office and we do this and this is what we do, and you're just trying to absorb some of those issues. And so it really is drinking from the fire hose. And then once a year, we have the chief district and chief bankruptcy judges meeting, which is just sort of the ongoing issue. So after you become chief, you would attend that annually. And we talk about the business of the courts, like the most recent issues, for example, are things like budget, cybersecurity, upcoming technology changes to the courts, those kinds of issues. So, and that's done on an annual basis. That one is not as bad though. It's a little more routine, I think, at least, than the other, than the chief judge's training. So that's what I do.
So Judge Urgano, what has surprised you, if anything, about the training or lack thereof you've had?
I think both what Judge Rodriguez and Judge Rose said is accurate. There's so much to cover that they can only do so much, that a lot of it is, depends on the situation. So I do think there are good resources, but as Judge Rodriguez pointed out, each district is different. So as a result, your needs are different district to district. So I think the training is good. I think the real benefit to the annual meetings is, quite frankly, sitting down with your colleagues and discussing issues of mutual interest and finding out how they're dealing with problems that maybe you thought were unique to your district that really aren't. So I think they do as good a job as they can. I think judges, and I say this with respect because we're at a CLE conference, there's only so many conferences one can absorb over the year. So having an annual training for chief judges is about all we can take. When you throw in the Fifth Circuit Conference, the bench bar, or the district conference, there's only so much you can do. The last thing I'll say is, the way I view the annual training is, at the Fifth Circuit, we get kind of a thumbnail sketch of what's going on in the administrative office of U.S. courts. At the Chiefs Conference, it's a little bit more detailed, and I make it an effort to write a very detailed summary of what goes on, so my colleagues have a better context of what's actually going on at the administrative office and how that impacts how they have to do their jobs.
So Judge